Ms. Ferris, are you able to hear me okay?
Yes.
And Mr. Brown, are you able to hear me okay?
Yes, Judge.
Okay, we'll go on the record in People versus Ferris. This is case number 246766. The record should reflect that Ms. Ferris is present today by video from Otsego County Jail. If I can have both counsel put your appearances on.
Larry Brown on behalf of Ms. Ferris.
Okay, Mr. Brown, what is the status of this file from a defense perspective?
And Your Honor, she is being charged in a 3-count complaint. There has been an offer made to which, if she would plead to count 1, the remaining counts, as well as any enhancements, would be dismissed. I discussed this with Ms. Ferris, and I believe that is how we are going to proceed.
All right, Mr. Rolla, is that a correct statement of the offer?
It is, Your Honor. This matter was actually adjourned for November 6th, specifically for that purpose.
Okay, and when you say enhancements, Mr. Brown, are we including the second or subsequent drug double enhancement?
Yes, that would be the enhancement.
Is that right, Mr.?
That's correct, Judge.
All right, Ms. Ferris, have you had an adequate opportunity to talk to Mr. Brown about this plea agreement?
Yes.
And is that how you wanted to proceed today?
Yes.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Ms. Ferris, are you currently on any kind of probation or parole?
No.
And you understand that by pleading guilty to count 1, which is possession of methamphetamine, that the maximum possible penalty you could face would be up to 10 years and or a $15,000 fine.
Yes.
With that maximum possible penalty in mind, what is your plea to that charge today?
Guilty.
Right now you have certain rights. I'm going to go through those rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes.
You understand that you're giving up and waiving all of those rights by pleading guilty.
Yes.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you would have to ask for the Court of Appeals to hear your case. They said no, that would be the end of any appeal. You understand that?
Yes.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anybody promised you anything other than what we said in court today?
No.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty because you are guilty?
Yes.
This happened back on September 20th of this year, is that correct?
Yes.
Okay, on that date, were you here in Otsego County?
Yes.
While you were here in Otsego County, did you have possession of some methamphetamine?
Yes.
Did you know that that's what that substance was?
Yes.
Did you have any legal right to have any amount of it at that time?
No.
Thank you, Mr. Rolla. Are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Brown?
Yes, Your Honor.
Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
Done by the people.
Mr. Brown?
I am not aware, and I also believe that the court has complied with statute and court rule for the taking of pleas.
Mr. Roller, are the people satisfied?
Yes, Judge.
Ms. Ferris, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Prior to that, someone from the probation department will be in touch with you for a pre-sentence report. Mr. Rolla, anything else that we need to ask?
Not after people, thank you.
Mr. Brown, is there anything that we need to address further today on this file?
No, Your Honor, thank you.
Ms. Ferris, did you have any questions at all?
No.
Okay, thank you. That's all for today, and the court's going to disconnect at this time.
Thank you.
And our next hearing is set for 1:45. So we'll be on a recess until Okay, Mr. Rao, are you able to hear me okay?
Yes, sir.
Okay. Okay, Ms. Siegel, are you able to hear me okay?
Good afternoon. Yes, I can hear you great.
Okay, good. We're on the record now in People versus Stephen Rao, case number 1346686. The record should reflect that Mr. Rao is present today by video from Department of Corrections. His counsel, Ms. Siegel, appellate counsel, is also present by Zoom video. On behalf of the people, Mr. Roll is present here in the courtroom. This was set for motion for resentencing. Just looking at the motion, Ms. Siegel, essentially you just need to get some more information and then get another date for this. Is that kind of where you're at?
Your Honor, I think the relief requested would be a resentencing. And if that's denied, if that's granted, we'll be back in front of Your Honor for resentencing. If it's denied, then that would be my last hearing in front of this court.
Right, but are you ready? Do you want to proceed on the hearing on the motion for resentencing today?
Yes, Your Honor.
Oh, okay.
If we were granted a resentencing, I would ask to come back on another day for that.
Okay, because I'm looking at paragraph 8 of your motion and it says counsel is not prepared to make her full argument in support of a motion for resentencing today.
That was at the date of the writing of the motion, in the motion. I wasn't prepared in my motion to make my full argument. I was up against a statute of limitations situation when I filed the motion, but then was the court in receipt of the brief that I filed subsequent to that?
No.
Okay, let's see here. Excuse me.
Mr. Roll, you're indicating you didn't get it.
We have what the court just read.
It sounds like the people did not receive your brief either.
Okay.
We got approved the service that says, please find and close defendant's motion for resentencing hearing, but it's the motion.
Your Honor, it looks like I mailed that. Is the court or prosecutor in receipt of my proposed orders granting and denying?
File here. Yes, I do have that in the file.
Okay, Your Honor, it does appear that there was an oversight in my office. When we mailed out the proposed orders, we were also supposed to mail out the brief, and it looks like that did not get included. So we could reschedule, or I could provide the brief via email. It's rather short, and the prosecutor and the court could take a few minutes to review it, or I could just argue on the record.
Mr. Roll.
Well, just accept, and that's fine for their position, but I don't even know what they're gonna argue because I can't respond to a brief I haven't received.
Or
Yeah, I mean, I think Ms. Siegel, I think I need to give the prosecutor an opportunity to respond to your brief before I can hear and rule on it. So
absolutely,
I
Your
guess
Honor, I'm sorry.
that's okay. I'm just gonna ask, I guess, that you just renotice the hearing. I'll assume that the briefs will be forthcoming and then we'll proceed further then.
All right, thank you. Sorry about the expenditure of your time. We'll get the briefs and a new notice out and be back on another day.
Okay. All
Thank
right,
you.
thank you. That's all for this hearing today, and all parties on this case are free to disconnect at this time. We're on the record in People versus Cole, case number 246749. The record should reflect that Mr. Cole is present here in the courtroom today. I could have counsel, but your appearance is on.
Thank you, Your Honor. For the record, we're going to.
Good afternoon, Judge John Steffi on behalf of Mr. Cole.
Okay, we're back here today. We adjourned the sentencing hearing previously to give parties some time to brief some issues related to the scoring. I did receive those briefs. I had a chance to review those prior to the hearing today. So I think we're ready to move forward. Mr. Cole, you now had an adequate opportunity to go through the pre-sentence report and talk to your attorney about that.
Yes.
Before we get to scoring challenges, Mr. Steffi, are there any additions, deletions, or corrections to the body of the report?
No, Your Honor, we don't have any factual issues.
Okay. And so the first challenge is the scoring PRB 1 and 5. Number one, whether either of them can be scored at all based on the 10-year rule. And then you have an argument that just factually PRB 5 shouldn't be scored. Is there anything that you wanted to state for the record other than what's in your brief?
Judge, you reviewed my brief, so I think I'll reserve comments until Mr. Rolla speaks. Thank you.
Mr. Rolla.
Again, Judge, as indicated in the brief, there is no 10-year gap. The defendant does not get credit for the time he absconded, but was still under federal jurisdiction, which he was under from January 21st, 2000 through August 22nd, 2021, as indicated in his adult history. There is no gap, period. So they're scoreable. And as far as the situation with PRB 5, as I also indicated in my brief, even were the court to not count those 5 points, it doesn't change the scoring levels nor the variables, Judge. So effectively, it's a moot point. Thank you, Your Honor.
Thank you, Mr. Steffi.
Thanks, Judge. There is a 10-year gap here. April 2024 is when this sentencing offense was committed. His previous conviction was October 24th, 2012 for OWI in Kalkaska County. That's more than 10 years. That's simple math. The issue hinges on whether his Georgia misdemeanor matter counts as a conviction. As detailed in my brief, per the statutes relating to the sentencing guidelines, as well as the actual sentencing guidelines book or manual, that does not meet the definition for a conviction. I attached the Georgia statute, as well as commentary from the Cobb County, Georgia District Attorney's Office that is plain and clear that a matter taken under advisement in that case, and in the Georgia case we're talking about, is not a adjudication, it's not a plea, it's not a finding of guilty. It is kept open, and then when successfully completed, the matter is dismissed via knowledge prosecution. So that's even more of a dismissal than our own DV deferral under 769.4a. So that's not a conviction. And I attached law 2020 unpublished case of Watson, which says that a DV matter taken under the 769.4a is not scoreable because it's not a conviction. So it doesn't count for the 10-year gap. And it doesn't count for PRB 5 misdemeanor conviction. So the statutes tell us that, and the law tells us that. MCL 777.50 defines convictions for scoring of the PRBs. And it specifically mentions some things that are subject to being convictions, such as matters that are set aside via expungement, as well as HIDA. And it specifies those are convictions. It does not list the DV deferral. It does not list 7411. I attached a case to which People versus James, that a 7411 case that was discharged and dismissed is not a conviction per the Michigan sentencing guidelines because it's not an adjudication of guilt in a criminal matter. Per that statute, as well as 769.4a, it's not a conviction, and a person who successfully completes that should not suffer any prejudice imposed by law upon conviction of a crime. That phrase was used in James to rely on that it's not a conviction. So that's important. That's critical here. That's really what it comes down to. So I attached the law as well as commentary from Georgia's largest prosecuting agency, which shows it's not a conviction. People versus Watson was also cited by Mr. Rolla, but Watson is clear. It holds that a DV deferral is not scorable because it doesn't meet the definition of a conviction. And it's kind of a weirdly worded case. I could see why Mr. Rolla perhaps misapplied or misapprehended this. But in that case, in Watson, the sentencing court went above the guidelines and the defendant appealed that sentencing. And his contention, the defendant, was that his criminal history was wholly accounted for in the PRVs and the guidelines. Whereas the reviewing court decided that, no, that's not true. There was things that weren't scored because they're not scorable that do apply. And that's why the court could go above the guidelines in that case. And Watson held or noted because defendant's domestic violence matter against KS was discharged under MCL 769.48, it was not a prior misdemeanor quote conviction under PRV 5 as well as 777.504. So I think that's clear. So without being able to score that Georgia matter that was dismissed as a conviction, it's also not usable to bridge a 10-year gap. And without that, we have a gap of more than 10 years from a 2012 misdemeanor to the instant case of April 2024.
All right, thank you. So again, I did have a chance to review the briefs. I looked at the law very closely, addressing first the 10-year gap issue. That's covered by 771.50 sub 1. And pursuant to that statute, the court has to determine the length of time between the discharge date of the conviction immediately preceding the commission date of the next offense. So just so that we're all clear, it's my view, and I think the statute is clear that we're dealing with discharge dates to commission dates of the next crime. And if that span is 10 years or more, then any convictions that occurred prior to that can't be counted when they're being scored. And so the court starts with the commission date of the sentencing offense, looks back 10 years to the discharge date of the most previous offense, and then so forth and so on until either there's been a period of 10 years that's elapsed or there are no further convictions. Addressing this issue of the interplay between convictions that are scorable or criminal offenses that are scorable versus those that apply to the 10-year gap rule. The court found a case, People versus Butler, that I thought explains that interplay very well. And that is that prior convictions that aren't scorable under a PRV could still be considered applying the 10-year gap rule. And that's because the statutes that cover the scoring consider the nature of the crimes, whether they're worthy of being scored under the sentencing guidelines, and which points to be assessed based on the number and severity of those offenses. On the other hand, the 10-year gap rule addresses the question of whether a defendant's prior criminal history should be considered at all because of the period of time that they spent as a law-abiding citizen. So that case basically stands for the proposition that even if an offense isn't scorable, it can still be considered under the 10-year gap rule because the consideration is there is, has this person not committed any crimes? Have they been crime-free? Have they been a law-abiding citizen for at least 10 years? Because if they have, then the prior conviction shouldn't be considered because they're just simply too old and not relevant. And so that legislative purpose, as stated in Butler, again, in my view, requires the court to look at where it's unclear, has this person been crime-free, law-abiding for 10 years, not whether those crimes are scorable, whether they've been expunged, whether they've been suppressed, whether they've been dismissed, whatever the case may be when you're dealing with cases from other jurisdictions as we're dealing with here or other states. In this case, I think it's pretty clear looking at that domestic violence, which I looked at Fayette County because that's what PSI said, where the offense occurred, Fayette County, Georgia. I also looked at the Georgia statute, which is 15-18-80. And that statute, in my view, reading that, gives prosecutors' offices in the state of Georgia pretty wide latitude in creating these pretrial diversion programs. The prosecutors in each jurisdiction are allowed under that statute to kind of dictate the terms and who's going to qualify for those programs, what it takes to get a charge dismissed under those programs. It basically just says prosecutors can do this. I looked at the Fayette County diversion program, which at this point, it must have been different in 2017. At this point, the current prosecutor in Fayette County, Georgia, does not allow domestic violence offenders into that program. Apparently they did in 2017, so I don't think there's any question that Mr. Cole did participate in that program. But I didn't find that helpful in terms of determining what his status was at the time he was on this kind of pretrial diversion program. The PSI indicates that he entered a plea on April 10th of 2018. So based on that information, the court would assume there was some kind of admission of guilt that qualified him for the entry into that program. Even if there wasn't an admission of guilt on the record in terms of a plea, in my view, Mr. Cole clearly accepted responsibility for that offense by participating in and completing that diversion program. And so therefore, when I look at that in the context of Butler, which is, did Mr. Cole remain crime-free and a law-abiding citizen for a period of 10 years, immediately preceding the conviction in this case, I find that he didn't, because it's clear to me that there was an offense that he committed of domestic violence, family violence in Fayette County, Georgia in 2017, that he participated in a program that allowed that charge to be dismissed, but that doesn't mean that he didn't commit the offense or that he remained crime-free and law-abiding for that period of time. So in my view, whether or not it's scorable, whether or not it was dismissed, again, looking at People versus Butler, the court finds that that charge counts in terms of the 10-year gap. So then we move to the next
Judge,
one.
if I may, regarding Butler, I did cite Butler, I'm familiar with Butler. Butler uses the term conviction. It's not a conviction. That's what matters, not whether it was dismissed, deferred, etc. So that is my point on that, and I think that there's emphasis, as well as the apparent lack of clarity on what happened in Georgia is a burden of the prosecution to show by preponderance of the evidence that it can't be used to be scored. And I don't think they've done that today. It's just when you mention the PSI says a plea, it's how everything is entered on the PSI. I'm not sure that that is a term of art in the way that we're analyzing it today, as well as the information that I provided the court in terms of it's a pre-adjudication finding. So I just like those points to be noted.
Okay, and I believe you made all of those points already. So unless you have something new to reiterate, we can argue back and forth, and then I can go through everything I just said again if you want.
No,
I'm re-emphasizing my points, so I'm making my ruling. Your position's been preserved for the record.
Okay, I just want to
You're free to disagree with it.
understand.
That's an appealable matter, but I don't want to just go back and forth here.
No, I just wanted to point out the distinction on Butler.
And you did point those out very well in your brief.
Thank you.
I just disagree.
Understood.
Okay, so that takes us back to the next conviction, which was in 2012, which is operating while intoxicated in Kalkaska. That's clearly within 10 years. The next one, I think as Mr. Rowland correctly pointed out, was the federal charges. The discharge date there was the 2011. So that one would count as well. And therefore, the court finds that the 10-year gap has not been scoring any of the PRV offenses in this case. So to the extent that the objection to the scoring of PRV 1 and 5 is based on a 10-year gap. The court denies those objections. You move to the question of is the Georgia domestic violence or family violence offense scorable under PRV 5, and that I do agree with the defendant that it is not scorable. I read the Watson case and it was more dicta in that case because it wasn't the crux of the issue, but I think it illustrates the point that courts clearly recognize that deferrals under 769 4A are not scorable under PRV 5. So the court will grant that challenge, and then the court will order that as to both SIRs and PRV 5 be scored and 0. So that means as to the R&O charge.
Your Honor?
Yeah.
I think it wasn't the offense 1 of 9. That was the one that was originally not scored. It's a misdemeanor. Wasn't that the one that the whole argument of the 10-year gap was based on?
That was based on the Georgia offense 6 of 9.
I mean, you should have at least one misdemeanor conviction that's scored though, based on the whole history of 1 of 9.
Okay, I guess we were all operating under the assumption that PRV 5, that the 5 points there was based on 6 of 9. That's not correct.
I mean, by my looks, he has, you know, but again, 1 of 9 is a scorable misdemeanor.
Okay. So you're saying this Davis never did score 6 of 9.
I don't know which, I know originally when she did this report, she had not scored 1 of 9.
Okay.
And then the supervisor, when he was reviewing it, disagreed and said, no, I think that should be scored.
Okay.
So the 5 points, I think, is still accurate. I don't know which one I don't think she was counting 1 of 9.
Okay.
But
I was just looking at 6 of 9. So Mr. Steffi, what do you say about that?
So they're saying that their misdemeanor score was for a 1999 assault and battery and not the Georgia 2019 matter?
Yeah. If that's the case, I think that's correct.
What's that, guy?
I think if that's the case, if they weren't counting the Georgia one,
And if they were judged, it would have been 10 points, not
right, is the only other way that the 99 Charlevoix County assault case wouldn't count as misdemeanors if the 10-year gap applied, which that it doesn't. So, all right. So I think then PRD 5 is correctly scored at 5. And again, I mean, it needs to be correct, but it wouldn't matter in terms of the guideline range. Okay, moving on to, that addresses the PRV scoring, and then Mr. Steph, you also objected to OB 13. Want to provide any argument, or did you want to wait to see what Mr. Rolla has to say?
I'll wait to see what the prosecutor has to say, Judge. Thanks.
Mr. Rolla, your brief didn't address OB 13.
I didn't judge, and again, this is a situation where the motion was filed on our office we received it at 3:47 on Wednesday, just for it. So I did this brief Wednesday afternoon and stayed to the office till about 8:30 to do it. So I did do that, but as far as 13, the allegation is that there's not 3 offenses within 5 years, as I understand what his argument is. And we're talking about the instant offense, which is occurring on yeah, 4/19/2024 with the conviction on 10/21. Obviously, you have that offense because you have to score it, and this is scoring for either offenses against persons or against persons and property. So that means you could go back specifically on the offense date all the way from 5 years back, and that's you're talking going back to would be what, April of
2019.
yeah 2019, right?
That's 5 years.
That would be 5 years, correct? But you can either go backwards or you can go forward. So I don't know if they were scoring in to include a different matter. I don't know. The only ones I see then would be the two offenses you've got, count 1 and count 2, that would be 2 there. I'm not sure what was scored for the third felony.
All right, Mr. Steffi.
Judge, yeah, I mean, there might be some, but there are not 3 or more crimes against a person for OB 13 as detailed in my filing. So that score needs to go from 25 to 0.
Judge, my apologies, but Mr. DeLeo just pointed something out to me. Although the subsequent offense that occurred allegedly on 8/13/2024, another resisting instruction, that was dismissed, the fact that it's dismissed, and he wasn't acquitted of it, it was dismissed as part of the plea agreement. That was two counts of resisting instruction. Police officers should actually make 4 within 15 years, within 5 years rather, so the scoring is actually accurate.
Okay, so to me, this scoring of OB 13 turns on the other 2 R&O offenses that occurred subsequent to this offense. And looking at the case law, People versus Nix, court can consider, and those were dismissed as part of the plea agreement in that case.
Correct, John. That's what I indicated on the record.
Right, so the court under Nix can consider conduct that was dismissed as a result of plea agreements in scoring OB 13. However, one of the touch points of OB 13 is, as it is with all the other OBs, is that before they can be scored, there has to be proof by preponderance of the evidence that those crimes actually took place, that the defendant committed them, and that they would be classified as felonies and crimes against the person. And of course, they occurred within 5 years, which in this case that's not disputed. So I find that those R&Os could be scoreable. They're not prohibited from being scored under OB 13 simply because they were dismissed as part of the plea agreement. But I think the problem is the only information I have about those offenses is that he was charged with them. And so I don't have any evidentiary support to find that the R&Os actually occurred, only that they were charged and dismissed as part of the plea agreement. So I think they're scoreable. What the court doesn't have is any evidence to support that. So the court is going to grant the challenge because under Nix, there was another case I read. I didn't write it down. It was that exact scenario where the court did not have a factual basis that would support the scoring of the dismissed charges. So for that reason, the court is going to grant the challenge. And the court will score OB 13, and this one would only apply as to the R&O charge, or that be scored at 0, which reduces the OB total to 11 points, and the OB level to 2, which then changes the guidelines from 5 to 23 to 2 to 17. So other than what we've already addressed, Mr. Steffi, are there any other challenges to the scoring?
1 second, Judge. Just trying to make sure. No, Judge, that includes all of the challenges that I had.
Okay.
Thank you.
Mr. Rolla, do you have any additions, deletions, or corrections?
Nothing then other than it's already been indicated on the record.
Any challenges to the scoring?
No, Judge, I think we've already covered that.
Okay.
Thank you.
Anything on behalf of the people for Outreach?
Judge, and again, I guess perhaps to reiterate the last point in regards to, I understand this court's not scoring OB 13, and that I guess falls on me because I suppose, had police officers here to testify as to those facts today. But again, with the filing of the motion, quite frankly, that wasn't a reality with the holiday situation. However, what's very, very clear is that Mr. Cole not only has a significant history of assaultive behavior, he did it and he got the benefit of having 2 other felony assaults to police officers dismissed. I think that the court has to take into consideration his prior behavior as well as his current behavior, including, by the way, the offenses that were not subject to being removed under the tenure gap. Thank you.
Thank you, Mr. Steffi. Anything on behalf of your client?
Yes, Judge, and just regarding the RNOs that were dismissed, I did provide a brief summary of the facts that I understand from that case, from consulting that defense attorney, and provided some case law as to why those were not actual crimes because you can legally resist unlawful arrest. So I think that's an important point to make regarding that past from now conduct. The PSI recommends a sentence of jail time followed by probation in this case. They are certainly able to look at no incarceration. His range is now 2 to 17. Mr. Cole is a valuable local member of this society. He's here supported by his long-term girlfriend. He's a father. He owns a business, which we discussed at a previous hearing regarding his driver's license. It's a bounce house business. He was able to stay crime-free for quite a period of time. And I think it's noteworthy because Mr. Cole served 10 years in prison from around the age of 18. And for someone to serve that much time in a prison environment and come out and be able to rehabilitate themselves to the manner Mr. Cole did is exceptionally impressive. It defies recidivism statistics across the country. And I'm frankly impressed with what he's able to do. What happened in the period of time from April through the summer was he had a kind of a emotional and physical relapse in his positive behavior. That's what led to him committing the offense that we're here for, the OWI, drug possession, and the RNO. Since he has been able to reflect on those things, since he has been sober, he's always taken this very seriously. I've seen him grow. I've been in physical contact with his family throughout this case. They support him. He has family here in Gaylord as well as Petoskey and Mackinac City, and his family here in town. So I would ask you to consider just probation, frankly, based on how he is a contributing member to society. And this incident was a blip on his general radar after he was discharged from this felony sentence in 2011. And I think it's important to note that. So I'd ask you to consider just probation. If Your Honor does choose to impose a term of jail, I'd ask that you allow him to do work camp. He wants to serve his family and his community and be employed and be productive. Thank you.
All right, thank you. Mr. Cole, anything you wanted to say?
Yes, Your Honor. I do fully understand my actions. I did have a rough, really 18 months to be honest. I'm already being punished because my bounce house business, I might have to lose it. I do got a family I let down. I let myself down. I let the community of Gaylord down, drinking and driving. I'm aware I could have harmed people in that process. Even with me spiraling out of control, I do recognize that I need some help in substance abuse areas. That it really just happened as of recently. I kind of fell off the wagon a little bit, but I do fully acknowledge and take full responsibility for my actions, and I got great sorrow for what I put my family through, myself through, and my business through, and I would love to to make amends with myself and my family, and whatever you impose today, I fully support, because I take full responsibility. So with that said, all I can do is account for what I've done and take full responsibility for my actions.
All right, thank you. I did read through the.
Sorry,
Okay.
this got lost in the scoring challenge issues. I did receive last night verification that Benoist says enrolled in counseling with Jeanette Sayer. If I may approach, I did provide Mr. Rolla this copy of this as well in court today, so I just want that to be part of the record. Further evidence that Mr. Cole is taking this very seriously. Thank you.
And you wanted this attached to the PSI?
Please, Your Honor. Thank you.
So Mr. Cole, again, I read through the report, so I'm familiar with what the circumstances that bring before the court here today. Obviously, I'm well familiar with your past history. I spent a lot of time looking at that as result of the scoring challenges. There's also a lot of information in that report about your background and your circumstances. Taking all of that into account along with what the lawyers had to say and yourself here, you know, there are some mitigating circumstances. Clearly, you've been able to get past your earlier problems, regardless of what happened in Georgia or the legal status of that. You know, that was really the only blip in a significant period of time, and so I agree with Mr. Steffi that that's something that the court looks at in terms of your prospects for going forward and not reoffending and getting back on the right track. And so those are things that I think give me some confidence that wouldn't be back before the court. The concerning thing, of course, is that you do have a past history, that you did reoffend in this case. The circumstances here are concerning to the court. You were pretty highly intoxicated. PBT was 0.14 and then blood draw was at 0.16. So almost at a high DAC or super drunk level that we consider here. Putting yourself and other innocent people who might have encountered you on the road in danger. Were found with a fairly significant amount of crack cocaine in possession, which is also concerning to me because that makes me wonder what else are you doing out there besides running your bounce house business. And you know, your behavior at the hospital, those folks are just trying to do their job. They deserve to put up with that. Their job is hard enough. Talk about the police, but also just the hospital personnel. They don't deserve to be treated in that way. And all of those things are factors which lead me to believe that there needs to be some punishment here. There needs to be a sanction so that you understand that that's wrongful conduct, that it's not going to be tolerated in this community. So I think a combination of supervision and jail time is appropriate here. I think a longer term of supervision than what's recommended is appropriate to make sure that you get on the right track, stay on the right track. The court is going to sentence you to 24 months of probation. The court is going to adopt as the conditions of that probation all the terms and conditions listed in the report. The court is going to order that you serve 9 months in the Otsego County Jail. You have credit for 2 days served. That's the sentence that's within the middle of the guidelines. I think it's fair. I think it punishes you for your wrongful conduct in this case, but also recognizes mitigating factors. The court is going to order that you serve the first 6 months of that in the jail. The court will approve your or not object to your release to the work camp program for the remaining 3 months of that sentence. The court is going to order that you pay a crime victims assessment of $130. Court cost of $325. State cost of $136, and supervision fee while you're on probation, $30 per month. All of that is as to the possession charge, and the R&O charge counts 2 and 5. As to the OWI charge, the court is going to order to serve 30 days in the Otsego County Jail, credit for 2 days served, fine of $250. No UIL reimbursement fee of $200 and $50 state cost. That sentence to be served concurrent to your sentence and the other charges. You do have the ability to seek an appeal of this sentence, and you have the appellate rights. Mr. Steffi, we're going to hand you the appellate rights. If you can have Mr. Cole acknowledge receipt of those, and I'll let you know once it's done that.
Yeah.
Appeal rights.
Benoist, do you recognize that I handed to you your appellate paperwork and that you've signed that under today's date?
Yes, sir.
Thank you.
Okay, thank you, Mr. Cole. You're remanded to the custody of the county at this time. When I can't finish this.
Yeah.
I don't think so.
Want to talk to him back here?
What's that?
Yeah, okay, with all our talk to him back here. Hey, sure. Gonna use the conference room for a minute.
Hey, Mr. Clayton, are you able to hear me okay?
I can, thank you. Good afternoon, sir.
I see your client is connected. We'll go on the record in People versus Key, case number 246773. And the record should reflect Mr. Key is present today by video, as is Mr. Clayton. Mr. Rolla is present here in the courtroom. This is set for a status conference today. Mr. Clayton, can you tell me the status of this file, please?
Thank you, Your Honor. This is the first status conference in front of Your Honor. I have not, and I'll be perfectly candid. I have not talked to Mr. Rolla about any offers. When we waived it up out of district court, it was just understood that it'd be appropriate as a circuit court resolution, but anything further than that hasn't been discussed. So I don't have a ton to report to the court today.
All right, Mr. Rolla, is there a plea offer in this case?
So I'm looking at that, Judge. I think there was. Handled by Ms. Brooker, so I'm checking to see the plea offer that she made. There was an offer of count one with full disclosure of source information regarding that individual's name, address, telephone number, verifiable ID for dismissal of count two individual.
All right, Mr. Clayton, were you able to hear that?
Just barely, but I got the gist of it. If Mr. Rolla, I went back through my emails, and I just didn't see any offer. But I did search Mr. Rolla's name. I didn't search Ms. Brooker's. I don't remember having a conversation with Ms. Brooker on anything other than just the waiver. But if I could get Mr. Rolla to simply email that to me, then I can do the guidelines and discuss it with Mr. Key. I do believe that this will be a resolution short of trial. So, but I just didn't hear enough. I heard some reference to full disclosure, count one, but I just need something to sit down and go through with Mr. Key. If I don't need a lot of time, maybe as little as your next motion day.
And Judge, it was done back on October 23rd, actually, but I'll be happy to put it into a written plea form and have it forwarded to Mr. Klein, so you can go with this client. People have no objection to an adjournment to allow him to do the same.
All right, Mr. Clayton, is there any reason why you can't have your client ready with the decision in the next 30 days?
No, that'd be fine, sir.
All right, so I'll set this for a plea hearing in a status conference at the court's full motion day in January. Mr. Key, at that point, I'm going to need you between now and then to talk to Mr. Clayton to go through that plea offer with him. And when you're back in court next, I'll need you to have made a decision about whether you want to accept any plea offers or go to trial, okay?
Okay.
All right, Mr. Clayton, anything further we need to address on this file today?
No, sir. Thank you.
Mr. Rolla?
No, Your Honor, thank you.
All right, thank you. That's all for today, Mr. Clayton and Mr. Key. You're free to disconnect.
All right. Thank you.